Okay, I think we've given everybody an opportunity to join. So let's start so that we can also, I'm sure you want to do something for the rest of your evening. I think before we get to the content, I want to look at three things again tonight. The contempt chapter, a bit on the contempt proceedings, and then the recent case law on the issue. Then under the Hague Convention, the one part that deals with defenses and refusals, and then also just the amendments to the Children's Act that is currently in the National Assembly. I try to find out exactly what's happening with it, and the feedback I'm getting is that it is currently in the National Assembly being debated. So it was published in the Government Gazette, but it hasn't been implemented yet. But it is important that we have a look at that so that you also understand how it will impact some of the things that we have discussed. It's the section that I'm discussing tonight is not comprehensive. I will share the Government Gazette as published that will have all the amendments in it. I'm just touching on some of it that impacts directly, I think, on what we've discussed and what this course is about. Okay, so those are the three things that we will touch on tonight in terms of the material. Then just maybe a little bit of feedback on your first assignments and portfolios. I think overall it went very well. So thank you for your efforts. I know it really takes time after a busy day working to also try to submit assignments. So maybe the first question where I asked your opinion on the principles of the Children's Act that's overseen. So what the courts do not look at. So some of you missed that one a little bit. And then some of you just repeated to me what the Act says. And that wasn't quite the question. The question is what of those principles are not applied by the court? So that was the one little bit of critique that I can give, but it's not a lot. And then the last one, the 46 question, one about the section 46 in which we will use. Again, some of you, I can see where you were thinking about, but then you sort of jumped to a conclusion without telling me more or less how did you get to that conclusion. So, but again, thank you very much. The idea really at the end of the day, do you know, this is not school. I don't have a memorandum where I have a little tick box and say, okay, a point for this, a point for this, a point for that. No, I want to look at your assignment and I want to see that you've looked at the material, you understand the material, and that you can go into a children's court or give advice to clients just based on what is parental rights responsibilities. So, what is Section 46 and how you can use it in practice to the benefit of your clients and even children if you act for them. So that is the purpose. And you'll see the next three questions that I posted is again that I want to understand that you looked at the material and that you understand what it's all about, and you can integrate it in a practical manner. You know, all of us, most of us, and I know there's some people that are not lawyers on the group, that we need to go and apply this in practice, you know, give advice. So I just want to see that is what you can do, and that's the purpose of the assignments. But thank you very much for your efforts and submitting it on time. And I know there was a bit of confusion, so again, sorry about that. Any questions or remarks from your side maybe about the assignments? Okay, if you think of something during the course of the presentation, you can always just put it in the chat box or just wait until the end and we can discuss it then. Okay, so I think for just connectivity, I'm going to switch off my camera while I'm doing the presentation. It just usually is easier on the connectivity. So first of all, as I said, I want to look at the contempt proceedings or contempt and how we approach it in terms of the Children's Act. Just need to find the right chapter. And then also it's interesting to then look at, we're going to look at the theory, but then I also want to go and look at the case that was a judgment of the Johannesburg High Court that was out last year that I want us to have a look at, because I think that's important if we want to bring in a contempt application, that we understand specifically what would be needed to be successful with that kind of application, because it's needed. I think we all, if I go around the group here and I ask, that it is that we all sometimes think that this case is a case for contempt, but what do we do? How do we go about it? And what is the criteria that the court will look at? So Section 45(2) in the Children's Act specifically deals with contempt proceedings. And I must say now here from the onset, you'll see when we talk to the amendments that some of the amendments lie in 45(2), but the principle stays the same. So that's, even though they've changed some of the amendments, the principles stays the same when it comes to contempt proceedings. So some of the general principles that I've highlighted and that you can find in the case law throughout is that all court orders, whether correctly or incorrectly granted, have to be obeyed until set aside. And I think that's, especially in family matters, you'll find that a lot of time the contempt comes from, but I didn't like that order and I'm not going to do it this way and I want to still do it that way. And that's not what it's about. If you're not happy with it, then there's certain procedure to follow. That and sometimes I think, especially if people are unrepresented, I think that after a court order, they can then elicit a debate about the court order. And then through that debate, by miracle or another, we're going to change the terms of the order. An order is an order. And you'll see also that is also, and you'll see that also how the courts approach it. If you look at the case law, that they say it for just for certainty, for the administration of justice, we cannot just decide what order to comply with and what not. No, that's never gonna that's not gonna work. So and a lot of I know there's a thinking going around that civil imprisonment has been abolished and the courts, but that's not quite true. Yes, the courts don't do it anymore for various reasons, but that it's never been found unconstitutional as far as I know, and maybe you know something different, that is still something the court can do. But I mean, I don't know if some of you appear in the Section 65 court, maybe the debt court. I know the courts will go a long way in terms of every month you will come back and explain and pay 50 rands, pay 100 rands, pay 500 rands. So there's different ways of enforcing it. But it's not, I mean, if you just look at the warrant of attachments, that's something that the courts will give. You can attach a house, or yes, it's difficult because there's other criteria now, but it's not impossible. Civil contempt is willful and mala fide refusal or failure to comply with a court order. And you'll see if we look at the case law, that is important, that those two criteria when it comes to the court orders. The court order must obviously be clear and unambiguous and capable of enforcement. And again, sometimes we as lawyers, when especially in the nowadays in the high courts where we draft our own draft orders, that we make sure, well, not starting with the draft order, but starting with your application, that the prayers you ask are clear and capable of enforcement. And I always sometimes like to do the exercise the other way around and say, okay, now I have the order. And if I get the order in this way, will it be able to be enforced? And if the answer is no, then my prayers is not clear enough. Then I must go back to the drawing board and relook at my prayers. And usually contempt proceedings are initiated by a notice of motion. That's common practice. The application does not have to be brought in the court that made the order. The applicant must show that an order was granted against the respondent, and the respondent was either served with the order or informed of its contents, and that he or she either disobeyed it or neglected to comply with it. So once that is shown, willfulness is normally inferred. So it's a bit, and then you'll see, especially if you look at the judgment also, then there's a shift in the onus. Then the respondent in the matters will then show why the non-compliance is not willful and not mala fide. So it's actually in these kind of proceedings, but it's, I want to say easy, but if you look at that judgment of the case that we will look at now of ND versus PT, that there is still, you need to place enough facts before the court to paint a little picture of the non-compliance, but you need to, but the some of the simple requirements is the service of the orders, the knowledge of the order. First of all, that there is a court order, that the respondent knows about the court order, and that he or she is not complying with it. And I think sometimes there is where it becomes a bit difficult. But once that is shown, then willfulness is inferred, and then the respondent must show to something to the opposite. So I say the applicant for a committal order must establish that there was an order, service or notice of the order, non-compliance with the terms of the order, and then and also, but I think all of you know that this is the one area in the civil procedure where the onus is beyond reasonable doubt. So similar to your criminal proceedings, but you can understand why. That if the person is found guilty of non-compliance, even in a family context, and you'll see the matter where we look at now, the court actually did impose a prison sentence, but it was suspended subject to conditions. So it is, I mean, it can be quite far-reaching, and that's why the onus is so high. And in application for contempt, and again, you'll see from the judgment, the applicant must disclose all the facts which might influence the court coming to a decision, and a failure to do so may result in an order being set aside or rescinded. So that really plays all the information in front of the court, that it's possible that you maybe think, and remember, also if it's an application based on a motion, it's easy in that in your affidavit just to tell the story. This is what happened, this is what happened, then this happened, and this happened. So a little story that you tell about the process in the matter or the history of the matter. In summary, it would be necessary to launch a contempt application to the Children's Court asking that. So investigation is launched into the non-compliance of a party to an order, a request that the non-compliant party is found to be in contempt, and appropriate sanction is imposed. So what is easier here, and you'll see that also one of my questions in the assignment deals with your Section 65 monitoring orders. And the reason why the court gives that is that because and it's usually given to a social worker that must give feedback to the court on the compliance, on the implementation of that order. And the social worker can do a little bit of that investigation, to place the facts in front of the court and go back to the court and say, this order is not working. And Section 65 monitoring orders are not only aimed on contempt, but it is usually, in the recent cases where I've been involved and where we've done this, is where the parties have entered into a parenting plan, and you think, no, this parenting plan is not going to work. An example, there was last year, there was a couple in the Children's Court, the mother and the father of a very young boy, like 1 year, 2-year-old, and he was living in Krugersdorp, and she's living here in Pretoria, and they decided on a shared residency regime. So 1 week in Krugersdorp and 1 week in Pretoria. And both the magistrate and I said, no. Yes, maybe he's now 1 year old or 1.5 year old. But what happens if he becomes old, and now you're looking at maybe creche, you're looking at all other kind of things. You cannot keep on this going up and downing, especially Krugersdorp and Pretoria. It's not that far, but I mean, it's far enough to be not just a quick drive to go to the next town. So we said, and in that matter, there was a Section 65 monitoring order made. Similar, if you really get the feeling that these bodies are settling just to get the matter finalized and get out of court, but you can think that the bomb is going to burst down the road, you will do the Section 65. So it's not always just for the possible contempt, it is just monitoring the implementation thereof. So let me see. I just need somebody to tell me if you can see the judgment. Just yes. Can somebody just tell me yes? Can you see it?
Yes, we can.
Okay, good. Thank you. Okay, thanks. So as I said, this is a judgment given by the Johannesburg High Court. It was already now, I see time has flown. It's last year already that the order was given. But it's a very good example of contempt proceedings and how you approach it. And it's also, you must go and read it yourself because it can become a bit confusing in terms of dates because there's different orders. But specifically, this order that is applicable here that the court is talking about the whole time is the order of 11 November 2021, which was dealing with the contact between the applicant, who is the father, and then the minor child, who is a little, it's not, you see the child in this this particular case is still very young. It's 19 months old and at that stage. And then the respondent was the mother. And just to give you a bit further background, the child was residing with the mother, needless to say, because the order was dealing with contact between the applicant and the minor child. So the applicant, when he brought the application, alleges that a lot of things. Basically, the respondent wasn't complying with contact in terms of video calls, in terms of paying for social workers' cost, permit the applicant to contact the child, allow the applicant's mother to facilitate the applicant's contact with the child in Johannesburg, and to make the child available for the applicant collection from the respondent's house in Johannesburg. So you'll see it's like your typical kind of orders that are made in terms of when telephone, when to be picked up, where to be picked up, who must pay, whose cost. So those are the things that the applicant came to say, okay, not happening. That order was made 11 November. So you'll see in the court, in the affidavits of the applicant, they fairly created timeline so that the court can see, especially what has happened when something has not happened, because that's important in terms of these proceedings that you, as I said earlier, you paint this picture. And I think using a timeline is maybe the best way to do that. So he says that initially there was a in-person contact between the applicant and the child. And then also there was one video contact. Then the social worker was to supervise all of this. The invoice became due or payable by the respondent on the 14th, and according to the applicant, the respondent failed to pay that. So I'm not going to go into all the detail of the cases. Those are the important facts that I just want you to keep in mind as we look at this discussion around contempt. One of the things, so maybe just I must mention that this was a Rule 43 application that was launched, and this order of 11 November 2021 was a Rule 43 order. So it was an interim order pending the divorce. So what the respondent in this matter, first of all, she moved to Cape Town while all of this was going on. So again, I mean, nothing wrong with that, but that just one of the facts. She moved to Cape Town, and then what she also did, just shortly after the judgment was given in November, she withdrew the divorce, forcing the applicant to launch the divorce proceedings afresh. And then the applicant, as part of his application, alleges that the purpose of the withdrawal was to fabricate the defense of no pending list to the respondent's non-compliance. So you'll see the judge discuss that, and I'm not going into that because that's not the issue here. So remember, there is this thing that if you can only do a Rule 43 if there's a pending divorce. So the thinking of the respondent was this, that if she withdrew the divorce, then the order of 11 November will fall away because the pending divorce is no longer there. And you'll see from the judgment that plan didn't work. Then also what she did further was she applied for leave to appeal to the judgment. And that was also dismissed. And it's important, and that's why I say it's important to list these facts, because if you then look at the overall cumulative facts of the matter and you see how the judge looks at it, you'll see you need all of these little conducts. And she responded to it. So it's not going to be like a one-sided, but it's important that you list this. And this cannot be disputed. There was an order. She did withdraw the divorce. She did file a leave to appeal. So this is really not really something that you can dispute. It's factually there. It's part of a court file. So that's important that you really paint that picture. So there's also the filing of like affidavits, and then the court, we looked earlier, remember in the first webinar, we looked at this best interest standard, and here the court even said that in J versus Day that is empowered and under duty to consider and evaluate all relevant facts placed before it, with a view to decide the issue which of paramount importance, the best interest. So yes, there was this further affidavits, and yes, it might not have been quite procedural, but ultimately the court must look at the best interest, and I'm not gonna stop there. Because that's not what's relevant here. So again, what this respondent now did, which is also typically one of these matters, is that now all of a sudden the applicant is a drug user. And she believes that he's now single, and because now he's a single person, he's now going to use drugs. So, but you'll see, this is now a new allegation that came on afterwards. And that the court also then, again, that painting the picture, that why all of a sudden now there's a drug use which wasn't ever mentioned before in any of the previous proceedings. And also what played a big role here is the age of the child, because the court said that the child of this age, you cannot have an interruption in contact. And the court found that, and that's the previous court, found that the respondents flagrantly disregarded the applicant's role as a parent, denying him contact for almost the entire young life of the child, at a time when attachment to both parents is critical to the long-term emotional well-being and psychological health of the child. Compounding this wrongdoing, the respondent relocated the child to Cape Town without telling the applicant. And this was in the Clark, if you look at that, was the previous application and not this application. And just a note here, the court here found that the respondent was aided and abetted by her attorney, who as an officer of this court was under a duty to act in the best interest of the child and not to advance the mala fide cause of his client. The attorney's willingness to fuel the flames of conflict was evident from both the tone and the content of his correspondence as annexed to the founding affidavit and the reply, both to the applicant's attorneys and even to and about the family advocate. Right, and what I think we spoke about this also before when we looked at sort of the general principles, and it's not there it's not a confrontational process, it's there to lead to harmony or hopefully or reconciliation, or not reconciliation, but at least a friendly way in dealing with the matters. And if you look at then this comment by the judge to say that the way in which her attorneys were looking at this matter or dealing with the matter, they were not acting in the best interest of the minor child. And in this case, the respondent admitted that she received the order, that she did receive the order and did not comply fully with the content of the order. But she denied that she acted willfully and mala fide in as far as she failed to comply fully with the order, alleging that she acted in the best interest of the minor child. And I think we've all have heard this before. I'm not doing this because no, it's in the best interest. I'm protecting the child. But it is a court order. If you don't like the court order, then go back to court. Sorry, I just want to take a sip of my water. So the judge says that according to, if up to here now, the issues are whether respondents' non-compliance with the order rises to the level of willfulness and whether it is mala fide. So the court, you'll see, looks at a bit of urgency, a bit of best interest standard, then also have a discussion around this, the absence of a list, of a pending list, because she withdrew the pending of the divorce in an effort to bypass the pending or the enforcement thereof. But if you look at the discussion of the High Court on this whole issue, they basically came to the conclusion that as they have certain inherent powers because of being the upper guardian, and therefore they're not going to be bound by the strict interpretation of the Rule 43 and the rule and the consequences thereof. So speaking again to what we spoke about in terms of the best interest standard, that when it comes to children and the High Court, they have this a wider discretion to look at things. When the court confirmed that she's looking and dealing with the paramount interest of a very young child and is an integral component, of the interest of justice. And therefore she says this whole thing around Rule 43 is impending, there's an order. And you'll see that if you read the judgment in detail, which I'm not going to, go through it with you now, the judge was not happy with this stunt, let's call it a stunt of the applicant, of the respondent, by withdrawing the divorce in an effort to not comply with the court order. So she says further, she did do the video call for that time, but according to her, it was not appropriate for the age and the needs of the child. And she then said, but, it's not. So she made the decision that it's not, and she didn't then allow it further. So she didn't deny it. She just said, well, I'm acting in the best interest. The further respondents' affirmance that the applicant should not exercise without supervision, be it in Cape Town or in Johannesburg, was substantiated by a reliance upon the applicant having a lithium deficiency requiring medication, the applicant allegedly being a drug user, and the fact that the applicant informed the respondent during the course of the marriage that he was molested as a child, alleged by a person living in the household in which the applicant is currently living, and that she was concerned of the child's safety. So the court says allegations of the applicant having been abused as a child were not raised before the previous judge, who noted and that even the drug use was raised at a late stage and never ever previously in any of her correspondence. And then they said, but clearly they've heard some of the respondents' concerns, and then that's why when they issued the order, there was this component of supervision, and therefore the court already dealt with that concerns of what she raised. Then the dealing with the non-payment of the social workers' fees, the respondent in this matter then went out and put out her expenses and her income and explained what she must pay and what she must pay. And then the court, after looking at all of this, the court says something doesn't make sense. I cannot make a finding as to the amount of the respondent's monthly disposable income. The respondent's stated version was that her income exceeded her alleged net monthly salary of 38,000, but the applicant declined to state what amount was made available to her by her family members. In addition, the respondent's averment of the amount of her average net monthly salary and the content of her salary slips were not reliable. And therefore that you know, this allegation that she didn't have money to pay for the social worker didn't hold water. In the result, she says, I'm unable to conclude that the respondent discharged the evidential burden resting on her in respect of her alleged inability to pay the relevant costs of the social worker and the monthly flights from Cape Town to Johannesburg. So what I come back to what I kept on saying is that all the facts, you must place all the facts. So if you're in the shoes of the respondent's attorneys or representative of some sort, all the facts, no, hide nothing, because you now have this duty as the respondent in a contempt proceeding to make sure that you place all the information before the court. The court says that the respondent consistently sought to frustrate the applicant's exercise of contact with the child. The lengths to which the respondent was prepared to go to prevent such contact was demonstrated by the respondent's withdrawal of the action proceedings. Such contact, being an attempt to subvert the order, reflected not only the respondent's willfulness, but also her mala fides. So sometimes be very careful that, sometimes we will advise that to clients, let's do this. But, careful how it can be interpreted by a court later on. Down the line, if there's any other kind of proceedings, contempt, or anything like that. Mala fides is a conclusion of law to be drawn from the facts in respect of the respondent's conduct. The withdrawal by the respondent of the divorce proceedings in the circumstances referred to above, a failure to negotiate an altered time for the video conference calls, and a failure to engage in respect of the contact in Johannesburg were indicative of the respondent's willful and mala fide failure to comply with the order. In the respondent's version before this court, the evidentiary burden resting on her in terms of the FACA judgment was not met by her. The respondent failed to advance evidence that established a reasonable doubt that her non-compliance with the order was willful and mala fide. The respondent's conduct, objectively assessed, demonstrated, in my view, willful and mala fide non-compliance. Absent compliance with the order, unless a respondent is able to establish conduct that is not willful and mala fide, that respondent is in contempt of a court order and it's obliged to suffer the consequences thereof. Objectively considered, the respondent did not provide an exculpatory version for her non-compliance. In my view, a finding of willfulness and mala fides against the respondents is justified. It is the only reasonable inference established by the respondent's conduct. And in the circumstances, I'm of the view that the respondent is willful and mala fide contempt of the order, and that the applicant discharged the onus resting upon him in the standard of beyond reasonable doubt. So they actually found her to be in contempt of the court order granted, and that the respondent is ordered to comply with it within 10 days. She's committed to a prison period of 20 calendar days. The committal order granted here is suspended for a period of 1 year on condition that the respondent complies with the court order granted. So you see, the court was in no ways afraid of enforcing the court orders, but you will also see from the way that the judge set out the facts that the applicant really did a good job in setting out all the facts to establish the timelines, to establish attitude, to establish the non-compliance. So it's not as easy as just, oh no, so there was no non-compliance, and that's why I wanted to look at that. So if you then start looking at those contempt proceedings, that you really have an idea of what is it you need to place before the court. Okay, any questions, comments? Okay, yes, Marina.
I'd like to ask, so if you're saying that you don't need to be in the same court to initiate contempt proceedings. So for If you want to initiate contempt proceedings for High Court order, can you go to the Children's Court, or which court would you go to?
No, I think they were in the they're more referring to High Court versus. It's an interesting question, but I would. My understanding of that was more that, let's say, the parties moved from Bloemfontein to Johannesburg, for example, that you can approach the Johannesburg court to say, here's a court order that was made by the Bloemfontein High Court. It's an interesting question. I don't see why not. Remember, the requirement is not a court order of a specific court. The requirement is a court order.
It's just usually more accessible and not that expensive.
Yeah.
Because it doesn't seem that complicated if you set out the facts and the non-compliance and the malafides that you might have to go 300 kilometers away to a high court to enforce it.
Yeah, no, it's an interesting question, and that's why I say I think if we just, and this is a debate, I mean, I don't think it's the final answer, but if you look at the requirements, it says a court order. You know, it doesn't say a court order of equal or of the same level court. There must be a court order. There must be knowledge of the order, and there must be non-compliance. So I don't know. I think why not? It's a valid court order that's not being complied with. Why not? I don't see.
Okay.
Any other questions, comments, opinions? The thing that I want to look at under the Hague Convention. No, my document has disappeared. That's not good. That's why it's disappeared. Sometimes the website closes down if you don't work on it long enough, and that's what now happened. Sorry, I lost my link because the site I wasn't active on the site. So the Hague Convention is, I know, something that's a lot of times is shrouded in a bit of mystique, and everybody wonders about it, and should we or shouldn't we? I think the problem is because it is something that everybody doesn't deal with a lot, because you don't really come across Hague Convention matters somewhere every day. Again, it's something that is prevalent in the Johannesburg High Court. I suspect because the chief family advocate sits there. Well, I don't really know, but for some reason or another, they have lots of matters. And also, again, in Cape Town. I always thought maybe Cape Town, because if people come to South Africa from other countries, I think a lot of times they end up in Cape Town. So I think that's maybe why they have more. But it's also in other courts. Again, something you don't come across a lot. It is, especially if you're the applicant, because the applicant in these matters are usually the not the state attorney, sorry, the chief family advocate, because if you look at the Hague Convention, they are tasked with bringing these applications on behalf of the central authority. So the applicants are usually the applicants. So if you come across these kind of matters, it will usually be as the legal representative of the respondent. So that is the naughty parent, if I can say that, the parent that abducted the child. Because even if you have a client that says, oh, well, you know, I woke up one day and my husband and the children were gone, and they managed to trace them to Australia, for example, your client in South Africa will again go to the central authority, who is the family advocate, and lodge a request with them for the return of the children out of Australia. So, but you can assist your client at least on if your client is the left behind parent, to initiate those proceedings. Well, proceedings is a strong word, maybe request in South Africa to the central authority, then that they will then ask Australia for the return of the children. If the parent that took the children, the naughty parent, are in South Africa, those parents are usually your clients. And if you represent the children, then the children in South Africa, because you'll see the Hague Convention says that children in these matters should have legal representation to make sure that their voices are heard. So the biggest thing you need to understand when it comes to the Hague Convention, especially, as I said, when you are acting for the respondents, is the possible, and that's why I want to look at this, is the possible defenses and refusals you have as a respondent that you can maybe be successful with to file or to as an answer to an application in terms of the Hague Convention. And you'll see the case law, if you go through them over a period of time, there's almost like a trend. Sometimes the courts are more willing to return, and then it's sort of, if the courts turn away and say, no, we're not returning children, and then there's a more inclination. Remember, the underlying principle of the Hague Convention is that if I am in a dispute with a co-parent about the residency of the children, I must stick to the country where we are habitually resident. And you see that's one of the tests to deal with the dispute. I cannot try to circumvent that. Let's say, for example, you are living in England, the parents, and there's now a dispute about the children. And you know the English law are, they may be a bit pro. I'm picking on the English, I'm not saying it is so, but they may be pro mothers, and you the father, and you say, I'm not gonna stay around and wait for this. And you take the children and you come back to South Africa because you think, oh, okay, South Africa, I might have a better chance. So the underlying principle of the Hague Convention is to say, no. If you are habitually resident in that country, you must stick to that country, first deal with the dispute there, and then only after that can you then move with or without the children. The Hague Convention, in terms of South Africa, it's not controversial, but a lot of the cases come from people that immigrate to another country, or they leave the country to go and work and stay there. And then there's a dispute in that country. And then what happens is, no, let me go home. Let me go to South Africa. Forgetting that by that time, the new country might have become the habitual residence, or and that you now need to stick. You cannot then say, come home to South Africa, because South Africa, in terms of the dispute, is no longer the place that will look at the dispute. So that's the underlying principle. And that's why it's sometimes difficult to oppose a return to the country of origin. So in terms of the Hague Convention, we will always talk about left behind parents. So that's the parent that are left behind when a parent and the children return to a country. But yeah, so you'll see it's not easy, these defenses. But again, if you just make sure, I almost want to say do your homework, but that's not quite so. But even, maybe you're in a position that you are called by a client that's in the UK or Australia or New Zealand or Canada, and say, look, oh, you know what, I want to come home, but I want to bring the children with. And then say, okay, but these are the things that you have to look at before just coming back with the children. You cannot just put them on the airplane and come back to South Africa. So Article 13 of the Hague Convention puts forward those defenses. And they are referred to as Article 13 defenses. And you'll see this, in terms of the Hague Convention, we do not refer to sections. They talk about articles. So if it established that the left behind parents were not actually exercising the right of custody at the time of the removal, that's a defense. That the left behind parent gave consent for the removal. But now be careful here, because I found in some of the cases, you can see the consent was not for a permanent removal. A long time ago, I did a case, and it's clear from the consent. It says, I consent that you can take the children for a holiday to your parents in South Africa. That is not the consent, that the removal. Because remember, if you remove the children here, the intent is to remove them permanently. So giving you permission to take the children to South Africa for holiday is not what they're talking about here. That there was subsequent consent to remove by the left behind parent. So let's take the holiday example. So let's say you left the country, you took the children, you came for a holiday to South Africa, and while you are here, there's a consent to say, okay, now what, you can stay there. That would what they were talking about here. That the child will be at grave risk to be exposed to psychological or physical harm if returned, or if the child will be placed in an intolerable situation if returned. Now, this is where it becomes difficult. One of the cases, you will see if you ever want to do research on this, and maybe you have a case. One of the cases, the lady came out of England back to South Africa, and there was an application for her return to England. And she then brought this up. It was domestic violence, there was abuse, there was this, and there was that. The court said, okay, but what did you do to protect yourself there? You know, what systems, what complaints, what cases did you open? And then she started like, oh, no, but the English this and the English that, and and the court said, no. And here the court sort of took judicial notice of the fact that, what, England has a fairly sophisticated family law system and domestic violence and family courts. And so, this excuse of yours that you didn't really know and there wasn't this and that's not flying. So this, and that's why I say, if you maybe get this call out of the blue from a person saying, I want to return to South Africa because of domestic violence, the court says, well, then you must come and show me that you did what necessary in that country where you were to try to protect yourself, to try to protect the children before you just came and you took the law. Because basically what it says is that taking the law into your own hands we're not going to approve that. You must come and tell us that it was your only option to do that. And telling us it doesn't make so. There must be some actions that you've taken, protection orders. And I suppose if you then say, well, I left the country that really didn't have these structures and really this was my only way to protect the children, the court will be more willing to understand or to believe that defense. But a lot of times that these defenses around psychological or physical harm becomes difficult because it's just this bare allegation of there was domestic violence or there was emotional abuse. There's nothing to substantiate those kind of defenses, and that's where it becomes difficult. So just keep this in mind. What I was talking about, so one of the requirements for the Hague Convention is that for the Hague Convention of specific country to kick in, you must be habitually resident. So that's also a defense to it to say that, okay, we weren't habitually resident in that country. Yes, we were living there at that stage, but that wasn't our domicilium. We didn't, and then you'll have to go and look at what is the meaning of that. What is habitual the meaning of? Because if you can make out a case that they were there for, and everybody knows that they were only there for 6 months because they were going there for or a year, and the intention was always just to be there for a year. It's going to be a year contract or a sabbatical or something. So there was never the intention to stay there. So it became a habitual residency. Then there's also something that you can use to say, well, don't return me to that country because that's not really our domicilium. So those are the things that you can look at in terms of the requirements more. There's also place for if the children has become settled in. So let me go back to my example of the father that left with the children to come back from England to come back to South Africa, and the mother now takes 2 years, to example, to apply for the return. So she would go to the central authority in UK and say, look, I want you to bring back the children to the UK. They removed contrary to the Hague Convention out of the UK and came back to South Africa, I want them back. Then the court can say, whoa, 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 whoa. First of all, there's time period. And the question the court will ask is, has the children not now become settled in this new environment? Just because they might have left the UK 2 years ago in, under circumstances, must we now return them? So that is defenses around children. And yes, the children's voices also play a role in the Hague Convention, but like in all things, if they were abducted in terms of the Hague Convention, that is not going to work. But it is a role that for sure that the court will listen at their voices. And a lot of times people hear the word abduction, but it is the Hague Convention is context. It's about abduction. And everybody gets very uppity because you're like, you can't tell me I abducted your child. But if you contravene the Hague Convention and remove the children without consent in contravention, in terms of the Hague Convention, the children were abducted. Still, in terms of the Hague Convention and these defenses, you'll find your answers a lot in the case law. The Hague, the convention itself doesn't give you a lot of information. You will have to go and see how the different courts apply these principles around these defenses. The latest one, or there was, as I said, that not all of them are reported, and sometimes they slip past us without really being noticed. But there is this one judgment now of 2021 that it's unreported, but it is part of your documents that you can go and have a look at, and in how the courts have dealt with that. Okay, any questions about that? The last that I want to look at is the amendments. And as I said, no, sorry about that. Let me stop sharing that document. Didn't want to work earlier on. So typically, and I think a lot of us have like, we've been really hoping and praying for these amendments, but they just not being affected. So you'll see that they were published on 5 January 2023. So this is almost almost a year ago. Although they've been published, they haven't been implemented. And as I said, last 2 weeks ago, at the beginning of the month, I did inquire as to where the amendment are in terms of the process of being implemented. And they tell me it's in the National Assembly being debated. So hopefully it will be debated soon, and then it will also be implemented after it's been published. I might have mentioned when we had our first webinar, it's also the same issue with the rules of the Children's Court. There's a whole bunch of rules that will govern case management, that will look at new forms. But again, those rules have been published, but they've not been implemented. They are now being translated in all 11 languages. And I really don't want to lie to you, but I think it's now been in the pipeline for 2 years. That they haven't yet implemented the rule because they are still publishing it. And if you look at the rules, and this is not the place all the time for it, but if you look at the rules, it will actually, in terms of the functioning of the Children's Court and how we do things in the Children's Court, will be very helpful, because it is more like all rules of court. It lists, or it sets out in a more practical sense how to deal with certain things. So it makes the case management that we now do informally in the Children's Court a bit more formal. So it gives it rules, it gives it timelines, it gives it guides. But as I say, when those rules are going to be implemented, by the time that I'm implemented, it's due for an amendment again. So yeah, that's the sadness of it. But hopefully with the amendment, we looking at it hopefully soon. The other thing is in the same, just a confusion issue, and I don't know if that's maybe also the problem around here, is that the Department of Social Development also wants to amend the regulations introducing new forms and new child protection units. And again, that's a headache that I'm not going to keep you busy with now. And I wonder if they're not, trying to affect the amendments together. But hopefully not, because those amendments of the department, it's going to take some time. But this is where we're at. I actually wanted to just for us to look at it, and so that when the amendments are eventually implemented, that you will keep that in mind. If you look at the Children's Act in some of the sections, that you could go, oh, okay, wait, there's an amendment somewhere that I must just keep in mind. You'll see some of it is it's just definitions that are changed, and it's clear from the way that they, for example, this first one about what is an abandoned child. They really just clarified on what is an abandoned child. And it is a new term that would need clarity in terms of the act. So they just gave it a definition. And the same with some of the other definitions, is just a clarification of a term that we might be using, but we need to give it a proper definition so that everybody knows what does, for example, abandoned child means. An abandoned child means a child who has, if applicable, no knowledge as to the whereabouts of the parent, guardian, caregiver, and such information cannot be ascertained by the relevant authorities. So, whoops, there you know what an abandoned child is. A cluster foster care scheme. The change here was just to include the Department of Social Development as an organization that can manage a cluster foster scheme. So previously, you could only have your certain organizations then had foster cluster schemes. So a foster cluster scheme would be typically, for those of us that are in Pretoria, we have the Rock of Hope, the Rock of Joy. They're all places of safety, of places of foster care, but that's why they all have similar names, the Rock of Hope, the Rock of Joy. They fall under an overreaching umbrella of an organization, and therefore they're seen as a cluster foster scheme of, but it has a specific, that idea that you have foster houses almost, and that they then, but as they are governed as a scheme. So this new definition then just includes the Department of Social Development as people that can manage those. The definition of orphan were changed. An orphan means a child whose parent or both parents are deceased. The old definition refers to no surviving parents. So again, it's just a clarifying of and a lot of times this comes from practice. I think that we've learned through practice that, if I say a term and you say a term, that we've realized that we sometimes talk about the same thing or not the same thing, but we use the same words. So some of these clarifications is just to deal with that. The removing of the definition of a social service professional and replacing it with the definition of a social service provider, which then it gives you a definition of what is a social service provider. It's a registered social service professional, occupation with South African social service professionals, and to practice and render services within the social service sector. Now, as I say, it's just a purer definition, because the old definition included probation officers and youth workers, which, if you're strictly thinking about it, yes, there are social service professionals, but do they provide services for the purpose of this act? They may be something else, not necessarily a service provider. So Section 24 is the one that we've all been waiting for, that will hopefully make our lives lots of easier. So Section 24(1) is amended to read as follows. Any person having an interest in the care, well-being and development of a child may apply to the High Court or Children's Court for an order granting guardianship of the child. I say this is what we're waiting for, and it says it's High Court or Children's Court that you can approach for their guardianship. Initially, when they My voice is going away. When they started this process of amending the Children's Act, they actually they wanted to limit the Children's Court proceedings or the jurisdiction to abandoned children or orphan children. And when they now eventually pushed this amendment through, they took that away, just to say you can apply to the Children's Court for an order granting guardianship of a child, which would make it just much easier to get guardianship, because the process, you can easily get a social worker's report, because currently in the High Court, and I think we had this discussion, is that they still need social workers' reports. But to get a social worker's report is an impossibility. So if you can go to the Children's Court, theoretically, I think it would be saying to the Children's Court, okay, here I am, here's my application. In terms of the Act, refer this to a social worker, because that procedure is already there, with the instruction to compile a report, because that's also already that process is already in the Children's Act. And then once you have that report, we're going to come back. And then also we'll get past this issue of the social workers that doesn't want to help. That I've recently, again, if they don't have a court order, Department of Social Development or any of these NGOs, they refuse to help with the guardianship applications. They say, no, you must go somewhere else. I don't know where that somewhere else is if you don't have money, because they are that's somewhere else. But hopefully then if we can go through the Children's Court, you have that referral, then this refusal of doing an investigation will be bypassed. There was a recent family forum meeting here in Pretoria, where the family advocate also said that they're willing to get involved in the guardianship matters. I'm also not quite sure how they're going to do the investigations, because a lot of times the social workers in guardianship applications will do home visits to confirm that, there's so many people living there, this is the income, this is what's happening. So it's a bit more practical approach. So I'm not quite so sure how the family advocate is going to do that, but let's see how they're going to do it. Then section 45 is amended, or just there's a new paragraph inserted, which refers to that the Children's Court can deal with which involves an unaccompanied or separated migrant child, or a child who is an asylum seeker or refugee as contemplated in the Refugee Act. I think, again, this was just inserted to make it easier for those children or NGOs to approach the court to protect the vulnerable. Then section 45(2) will read as follows: the Children's Court must refer any criminal matter arising from the non-compliance with an order of such court or a charge relating to any offence contemplated in section 305 to a criminal court having jurisdiction. And that's why I said when we looked at the contempt proceedings, the amendments, if implemented, it's now very clear that the Children's Court must refer the matter, the criminal matter, to a criminal court. The old section, or not, let's say the section as it stands now, gives the Children's Court that the jurisdiction to convict, but it's now taken away. If one presumes that the prosecutor will take on these matters, it might be a deterrent for parties to do not comply with court orders, that they will be prosecuted in a criminal court, which is a bit more harsh. So maybe that idea, that you say, oh, no, you're a social worker, who are you? You can't do anything to me. So maybe, it's involving a criminal court. I'm sure a lot of you might have ever had dealings with the criminal justice system, and that's frustrating in itself. The police and everybody that goes with that process. And in any way, also, as I say here, to convince them to actually open a contempt case it's almost also an impossibility. But they do that, and maybe if the policeman knocks on the door of that lady, let's go back to our court case, that's refusing access, and there's the policeman with his uniform and the blue lights, and maybe, then maybe there will be a bit more serious on this non-compliance of court orders by the Children's Court. So I said to link the amendment of section 24. Remember now, because we say section 24 is changed, we need to change there's section 45, because Section 45 deals with the matters that the Children's Court can deal with. So we have to link the two. So they insert 3A and 3B in 45. So the type of matters that the court can deal with. And they say that the High Court and the Children's Court have concurrent jurisdiction over the guardianship of a child. So you don't have to not go to the High Court. You still, if you really, really want to, you can still go to the High Court. And 3B reads that the High Court, Children's Court, and Regional Court have concurrent jurisdiction over the assignment, exercise, extension, restriction, suspension, or termination of guardianship in respect of the child. Now, this is interesting. I recently, last week, had a discussion with one of the presiding officers in the Children's Court, and her interpretation of this amendment, she sees that if you go back to Section 24, it has the 3 sections in terms of what you need, the consent of both guardians. And you'll see and you remember that the one deals with the removal of children from the country. And her interpretation of the amendment is that, yes, the Children's Court can now give guardianship, but that 45, I think it's 45 to C, let me just go, let me have a look, 24. So I'm not the wrong one, 18. Yeah, so Section 18.3, where it says that the removal of the exclusive jurisdiction of the, no, it is 20. Oh, why can I not find it now? I'll find it right now. She says that on her reading of it, the Children's Court will not have jurisdiction to consent to a child being removed, because as she reads the amendment, even yes, though the Children's Court can deal with guardianship, she's of the opinion that you will not be able to give the Children's Court to give consent to remove the child from the country. I'm not sure if that is so, but that's her interpretation thereof, because guardianship is guardianship. If it's, I don't see why she's differentiating between guardianship for one type of matter, but not guardianship for another kind of matter. But I mean, maybe it's something that will be tested and there will be clarity on it. And that's her reading of it. It's not, I'm sure, not the only reading of it. The other interesting effect that this will have, a lot of times that you'll find that some children's courts, and I've found a few of them that will say, no, any parenting plan that mentions guardianship, they can't make a court order. And then some of them I've even known has gone as far as to change, you must take out the word guardianship in a parenting plan if you want them to make it a court order, because their strict interpretation thereof is that they, as a children's court, cannot make guardianship orders. And therefore, any agreement that mentions guardianship cannot be made a court order. So, I mean, there's 2 approaches. I've come across courts that have made me amend parenting plans because they don't want it to have guardianship. And then the others will just, like, as I say, they will just like gloss over it and go, oh, you know what, let's make as if it's not seen, because it's part of parental rights responsibilities and we have jurisdiction over that. So yes, the word guardianship is maybe somewhere there, but we're just going to make as if it's not there. But when now they have specific jurisdiction, then hopefully, this kind of weird approach is no longer necessary. Then 150. So 150 is the deals with when is a child deemed to be in child in need of care and protection. So it's just a wording change that they've input in there to say have abandoned or orphaned, and you just need to go back to the definition of those words. And then section 1H by deleting the word or at the end of the subsection. And then thirdly, section 1 small or I reads as follows: if a child is being maltreated, abused, deliberately neglected, or degraded by a parent, caregiver, or person who has parental rights and responsibilities, or a family member or a person in whose care the child is. So the change is here, they took away the words under control to be replaced by care. And I just raise a concern because care, again, has a very specific meaning. So my question I've asked is that, are you not excluding certain categories of people by replacing the word under control with care? Wasn't it better, wasn't it a wider meaning under control, and thereby you can have maybe protect more children? So that's just a concern that I've, a question that I'm asking. They then insert a subsection J to L to also have these category of children to be deemed in need of care and protection if it's an unaccompanied migrant child from another country, it's a victim of trafficking, has been sold by a parent, caregiver, or guardian, which is also trafficking. But again, just maybe they've realized there's some gaps in the Act to clarify and as I said, I think it's just increasing the pool of children, that it's easier to say they're deemed to be in need of care and protection if they fall under one of these categories. And a big part of these, and this will hurt your heads at this time of night, is they've now in certain time periods in the sections. And the interpretation of this 90 days, I'm sure it might lead to some problems down the line. But what they've done is 152, there's a designation, a designated social worker must investigate the matter and within 90 days compile a report in the prescribed manner on whether the child is in need of care and protection. The words that are removed are before the child is brought before the court. A social worker must. So if you read this section in conjunction with section 151 and 152 of the Act, which deals with the removal, it would seem that this report would therefore refer to investigation following the removal and not be for the removal. It just makes sense. Then 155.5 is amended to read that if after an investigation in subsection 2, the designated social worker finds the child to be in need of care and protection, the child must be brought before the Children's Court for a hearing in which the court must make a determination. I said the amendment seems to apply that there should be a hearing in all matters in which a child to be found in need of care and protection, for which the hearing of the child must be present. That's on my reading of the amendment. And I'm just saying that if, the Act and the rules, if they ever implemented, are clear that all matters must be dealt with quickly and as possible. And taking each of these matters into a hearing will not achieve that. And if the matter is to go on trial, the child would have to be legal represented to ensure that his or her rights are protected. And that cannot always be left, because that representation cannot be left in the hands of the court or the designated social workers. Also, the rules will still ensure that this process, so the rules will also play, if you read the rules, on how this will be implemented. So, yeah, words like must in any section of any act also always bothers me, because if must, I suppose it can work both ways. It can work in your favor, but it can also work against you in terms of just delaying the finalization of things, of cases. So 1556, again, I think a lot of you that have dealt with children's court matters, a lot of the critique of children's court is this idea that this cases just go on and on and on, and sometimes it's postponed for 30 days and sometimes for 60 days and sometimes for 90 days, and which is the correct process and the correct time periods. A lot of the amendments, in my opinion, they've tried to clarify some of these time periods so it's clear. So 1556 says that the children's court hearing the matter may adjourn the matter for a period not exceeding 30 days at a time, and order that pending the decision of the matter must remain in temporary safe care, be transferred to another place, remain with the person in whose care the child is, be placed in the care of a family member or as a relative, be placed in a temporary safe care. So it seems, that's why I say they're trying to clarify these issues about the 30 days and the 60 days. That you don't get these long postponements. The rules also, when it comes into operation, also tries to deal with some of these time periods that you can postpone matters. Again, they've meant the insertion of the word care in this also limits. They've taken the words out of and in control and replaced it with care, which for me brings the same concerns that with the other amendment. 156, the amendment there is the insertion of paragraph 1C, capital A, which will now read that the child is be placed in the care of a parent or a family member if the court find that such person is suitable person to provide for the safety and the well-being. So that's a new paragraph they've put in. Before the amendment, this specific section had no mention of family members who can be considered for a possible placement. So, and I think you all know that sometimes finding placements for children are really a headache. So this insertion of the family member might be a good thing, but it still must be a suitable person, and that's important that we read the suitable, because we cannot just now assume because the person is a family member that he or she will be okay to look after the child. And then 157, the amendment there deals with disability or the stability of the child. And it says a child who is 3 years of age or less, who has been orphaned or abandoned, must be available for adoption in the prescribed manner and within the prescribed period, except when it is not in the best interest of the minor child. So the amendment introduces specific age when a child must be made available for adoption. And then you must also look at the new definition of an orphaned or abandoned child. Then 159 is just your extension of your placement orders and then how to deal with that. Then 159, they also made amendments again by inserting some of the new definitions of an orphaned or abandoned children. And then what's important that this deals with, okay, that the new section refers to a situation where there's no family member available. Prior to this amendment, children might have been placed with a family member which might not be a family member. This amendment, in my opinion, does not make the placements irregular or invalid, because at that stage they considered that person as a family member or a suitable person. So section 160 just refers to the regulations that they can put in place, and as I say, they were already looking at that to amend the regulations to TSD to make provisions for child protection units, for assessment, central assessments. It's really, and if I look at those regulations, and I won't bore you with that, I really don't know how they're ever going to implement all of them. And then 185 deals with the number of children to be placed in a foster care per household. It's replaced to say not more than 6 children may be placed in a foster care with a single person or 2 persons sharing a common household in terms of the registered cluster foster scheme. So yeah, there was a gap that sometimes they would place 6 children per person. So the wife will get 6 children and the husband will get 6 children. So the amendment is now saying, you a household. There's 6 children per household, not more than, what more than 6. This is part of your chapter, sorry, that is part of the course, and you can have a look at that. These last amendments is really to deal with a lot with foster schemes, foster placements, how the renewal takes place. So it's very specific to a specific part of the Act. And if you deal with foster placement and you wonder if it's going to be amended, maybe just go and have a look at those proposed amendments. But again, this is the amendment that has been published, but it's not been implemented yet. So this is really just for you to keep in the back of your mind for when it is implemented, so that you know that you need to consider the amendments. And the biggest one that will affect all of us mostly is the guardianship one, which is a positive change. In my opinion, I don't think it's a negative change. Okay, any other questions, comments? Yes, Kathleen.
Hi, Elizabeth. I just have a question. I see in the notes, when you click on the amendments, it doesn't actually show the document that you just showed us. I'm not sure if they just maybe didn't load it properly or what. So
okay, but I'll share it somewhere. Yeah, no, what I'll do is once I'll share it here in the chat.
You.
So then I'll share it there. Okay, good.
Thank you.
Thanks. Okay, any other comments, questions? Okay, well, I think it's 7 o'clock. I did try to sort of finish by 7 so that all of you still have time to have a nice dinner and relax after a hard day. Then the assignments, the course ends on the 30th, which is when Thursday. But let's all agree that you can have until Friday to submit your assignments. Then I will try my very best to finish marking them by next week, during the course of next week, so that you can get your final results by the 7th of December, so you can also know what's happening. But thank you very much, everyone. I just want to quickly see if I know sometimes it's a challenge to insert documents, but I'm gonna try, and then I'll insert it in the chat. Otherwise, I'll just upload it separately. Maybe I'd rather do that. I'm going to upload it separately onto the web page, so under announcements, so that you have it there. Okay, thank you, everyone. If there's no other questions, then enjoy the evening further.